Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 6 regarding the new medical legal fee schedule. And as I promised you in our last session, I was going to wait approximately 2 weeks before coming to you again to allow sufficient time for us to experience and live in the new medical legal fee schedule to see what that experience has shown us and what that experience has taught us about how to succeed within the new game that we find ourselves in, which is referred to as the new medical legal fee schedule. And I have a fascinating program for you today because, as I said, we've now had the opportunity to approach the implementation date of the new medical legal fee schedule. We've had an opportunity to realize the effective implementation of the medical legal fee schedule. And now 2 weeks after that, we've had the opportunity to experience cases, new cases, both coming in on the intake side of the equation and also new cases going out on the completion and the billing side of the equation. And I want to share with you in today's session what we've learned about how to operate on both sides of that equation. And in addition to that, I want to share with you some insights as to how to operate in the middle of that equation, which involves the new face-to-face evaluation. So I have a fascinating program for you today, which I'm sure is going to help you tremendously as you move forward into the remainder of this year, operating under the new medical legal fee schedule. So before we get into today's discussion, let's just briefly review where we've come from so far in this discussion. In section number 1, we began approximately 1 month before the effective implementation date of the new medical legal fee schedule, and we talked about why it is that we find ourselves at this crossroads in our career as qualified medical evaluators on the precipice of the necessity of a new medical legal fee schedule. And I shared with you the philosophy of both the claims payers, the philosophy of the entire workers' compensation system, and the dwindling supply of qualified medical evaluators. And I shared with you the philosophy from the side of the qualified medical evaluators, all three forces of which conspired to demand a new medical legal fee schedule, which brings us to where we are today. In sessions 2 through 4, I shared with you the new medical legal billing codes, and we compared and contrasted the old medical legal billing codes with the new medical legal billing codes, and we reviewed how the old medical legal billing codes had built-in incentives for both the qualified medical evaluators and for the claims payers. And then we compared and contrasted the old medical legal billing codes with the new medical legal billing codes to see how those incentives have changed. And let's be clear, the new medical legal fee schedule has built-in incentives for both parties, and both parties intend on fully exercising their incentive and fully realizing their incentives. Now, there are some areas where the incentives of the claims payers and the QMEs coincide, and there are some areas where those incentives collide. And we talked exactly about those in these 2 sessions. I also gave you some case examples as to how each of the new medical legal billing codes can be used. I gave you an example of an initial comprehensive evaluation. I gave you an example of a reevaluation. And I gave you an example of a supplemental report and showed you exactly how to code those on your HCFA 1500 billing form. And we began to introduce the concept of how you as the qualified medical evaluator can succeed with the new medical legal fee schedule. And I have some more secrets of success for you today. In our last session, we came upon the effective implementation date of the new medical legal fee schedule, and I shared with you some new insights that had been gained as new cases started coming across our desks. As the phone continued to ring with appointment dates scheduled for after April 1st, 2021, we started to get a look as to how these cases are going to be managed from all the way from the inception of the first intake phone call all the way through to completion, to putting that report in an envelope, putting a stamp on it, and taking it down to the post office. And the entire procedure from inception to completion has changed. And I started to share with you some of those changes in session number 5. And that brings us today to session number 6. And in today's session, this is being recorded approximately 2 weeks after the effective implementation date of the new medical legal fee schedule. And so now we're fully in the throes of our new system, and every new case that comes in is being evaluated under the new system, and the old system is being ushered out and sent to pasture as nothing more than a fond memory. But we're developing a new album of new memories and new experiences with the new medical legal fee schedule, and I want to share with you today some of the strategies that are evolving as to how we as qualified medical evaluators can accomplish 2 objectives. Number 1, how we can help the other players in the system realize their incentive, which is better quality QME reports. Number 1, how we as qualified medical evaluators under the new medical legal fee schedule can contribute to better quality reports so that the other side, the other parties, can experience a win under the new medical legal fee schedule. And number 2, how we as qualified medical evaluators are going to win under the new rules of the new game of the new medical legal fee schedule. And I have several new insights to share with you today. Okay, so let's begin today's session, which is number 6, our next to last and next to final session. I have a surprise for you in our final session, but this is our next to last session of our discussion of the new medical legal fee schedule. Okay, so let's begin. And as we begin today's discussion, what I want to share with you is I want to share with you several examples as to how the new medical legal fee billing codes are used. And I want to give you some actual case examples. And our overriding theme and our overriding philosophy as we talk about the new medical legal fee schedule is that time is of the essence. And I began talking to you about this concept in our last session. Under the new medical legal fee schedule, with the exception of the codes that relate to billing for depositions and the code that relates to billing for review of sub rosa videotaping, all of the medical legal billing codes involve flat rate fees. There no longer are any time-based billing codes. So time and the opportunity to bill for our time and the opportunity to take the time and the opportunity to spend the necessary time in producing a high quality report and arriving at opinions and conclusions that are accurate has been taken away from us. We no longer have time-based billing codes. What we're left with under the new medical legal fee schedule are flat rate fee billing codes. So time is the one variable that we need to manipulate in order to succeed under the new medical legal fee schedule, because without accurate and adequate attention given to the time devoted to the essential activities, profitability can quickly diminish down to next to nothingness if you fail to properly use your time in a cost-effective manner. So the recurring theme throughout the remainder of our discussion is that time is of the essence. And I want to share with you several key choke points where you can save valuable time and thereby improve your profitability under the new medical legal fee schedule. And in today's discussion, I want to share with you some examples as to just how to do that by talking to you about several examples of new evaluations, re-evaluations. I have another new evaluation that presents a slightly different scenario, and I want to share with you how time factors in to these evaluations. But before we begin with those discussions, I want to share with you a story about a new intake that came across our desk on April 1st. And I'm sure you will find this story to be relevant and to be quite interesting, and may even cause you to pause and to reflect a little bit upon where we might actually be going with the new medical legal fee schedule. Okay, so I want to share with you a story that may change some of your perspective regarding the new medical legal fee schedule. And as many of you know, I was at the Medical Legal Fee Schedule Committee meetings. I participated in those meetings. And during the course of those meetings, I realized that the ML104 billing level was quickly disappearing and being ushered out due to the demand of the parties. And being primarily an ML104 writer myself, I feared that the new medical legal fee schedule would reflect a pay cut for me and for many other qualified medical evaluators who spend quite a bit of time in producing accurate opinions and conclusions. And so as my fears were realized and the new medical legal fee schedule adopted in and ushered in indeed the new flat rate billing fees, I became publicly, openly critical of the medical legal fee schedule. And if you've been participating in this discussion up until now, you know that I've been skeptical and even critical of the new medical legal fee schedule. Well, time is a great teacher, and I want to share you a story about what happened on April 1st, the effective implementation date of the new medical legal fee schedule. On April 1st at exactly 5 p.m. in the afternoon, as I was closing up business for the day, I noticed that UPS truck was coming into my driveway, into my parking lot. And I greeted the UPS driver, who was laden in both arms with a case of paper. It was the same kind of case of paper that you would get if you went to Office Max or Staples to buy a case of paper. A case of paper holds 5 reams of paper in a stack in the left-hand side of the box and 5 reams of paper in a stack in the right-hand side of the box, for a total of 10 reams, each of 500 pages in a case of paper. So this was brought to my door in a case, a copy paper case. And I had no idea what was going on, but I got out my knife and I cut the tape off of the box, opened up the box, and there in the top of the stack of medical records on the left-hand side of the box was a declaration from the defense attorney. And the defense attorney, surprisingly, was ahead of the new medical legal fee schedule and had the declaration done exactly on time for the effective implementation date of April 1st, 2021. So I realized that what I was dealing with here was the medical records having to do with one of my upcoming new initial comprehensive evaluations. So the initial comprehensive evaluation is billed under the flat rate billing fee of $2,015. Well, as I looked at the declaration from the defense attorney provided a declaration that attested to a total of 4,486 pages of medical records. So being the way that I am, my mind started quickly doing some calculations, and I realized that that was 4,286 excess pages above and beyond the 200 pages that are compensated under the ML201 initial billing level. So, of course, I did some math, and before I did some math, I took a photo of those medical records. And here is what came out of this case of paper from the defense attorney, and here is the declaration right on the top of the stack. So I quickly did some math, and my math formula at $3 per page told me that the review of records alone involved with this case would be $12,858 simply for the review of records. And if you add the $12,858 for the review of records alone to the flat rate billing fee for the evaluation itself of $2,015, that brought the total evaluation value to $14,873 and no cents. And on the first day of the effective implementation date of the new medical legal fee schedule, at 5 p.m. at the close of business on that day, when I was openly skeptical and critical of the new medical legal fee schedule, into my lap falls a case with a value of $14,873, the largest case of my entire career as a qualified medical evaluator, going back over 25 years. The largest case of my career came in on day one of the new medical legal fee schedule. Can you believe that? I could not believe that myself. I could not believe that myself, and I wondered what was the significance of this. Was this an omen of good things to come? What did this mean for me, for my future, for the new medical legal fee schedule? Well, I can only tell you that I considered this to be great, great news. Well, the next day, after I got my wits back about me, I called up the defense attorney's office to raise some questions about this stack of new medical records, because I wanted to see if they could provide me any kind of insight as to how to attack these 4,486 pages of medical records. And lo and behold, I was able to get hold of the assistant who had assembled this stack of medical records. And the question that I had for her was, what is the order of this stack of medical records? In other words, as I start to go through this stack of medical records, should I go through the left-hand side of the stack and go down the stack? Are they in some order that way? Or are the stacks read from the left-hand stack to next the right, the stack on the top of the right-hand stack, and then the next one here and the next one here? Or what was the order? What could she offer me to help simplify or to help organize my review of this huge mountain of medical records? And I asked her, are these records arranged in any kind of date order or what? Well, she responded that she was sorry that their system, their particular system, does not allow them to sort the records by date, and so no, they were not in any kind of a date order. And I said, well, should I read them horizontally, or should I read them vertically, or how should I approach them? And she advised me to approach them down the stack, and then once I was done with the left-hand stack, I could go to the right-hand stack, and there might be some sort of arrangement to them in that direction. So I sat down with these stacks of medical records, and as I started going through these medical records, I realized that there were many duplicates contained within these 4,486 pages of medical records. In fact, it was not uncommon to have 10 duplicates of a single document. And one document could be a 4 or 5 page report with 10 duplicates then comprising 50 pages of records of duplicates. And that pattern persisted through the entire 4,000 pages of medical records. There were many duplicates. And I realized that the insurance company, the claims payer, at $3 a page was paying for thousands and thousands and thousands of dollars of review of records that were simply duplicates. And I had the realization that at the defense attorney's law firm, the defense attorney's law firm was comfortable in providing a declaration for 4,486 pages and for paying me as the qualified medical evaluator $12,858 to go through this stack of medical records, whereas the secretary at $25, $30 an hour could have gone through this stack much cheaper. But the defense attorney law firm was comfortable in spending the claims payer's money to have me go through this at $3 a page. And I realized that eventually the burden of the review of records, the parties are going to realize that the burden for reviewing the medical records has fallen squarely on their shoulders. Now, certainly we're not going to be getting these types of cases in the future with thousands and thousands of pages of duplicates of medical records. The insurance companies and the claims payers are going to realize that that's simply too expensive, and they are going to spend the time, effort, and energy necessary to pare these medical records down to the relevant medical records. And I was able to get about 900 pages of relevant medical records out of these 4,500 pages of medical records. And I think the parties are going to have difficulty handling the review of records when they realize the burden, which up until now has fallen squarely in the qualified medical evaluator's lap. Now, I'm more than happy to review these medical records at $3 a page, but I don't think the claims payers are going to persist in sending us pages and pages of medical records that are duplicates. They are going to spend the time, effort, energy, and resources to have the medical records managed and pared down to only those medical records that are relevant. And I think the claims payers are going to realize the gravity of their decision as to how their stern approach and hard line to paying for the review of records has now landed the burden of the review of records squarely in their lap. So in this particular case, it's a hugely profitable case, and I'm happy to have it, and it's changed my perspective a little bit about the new medical legal fee schedule. And the philosophy of the new medical legal fee schedule is that we have to be prepared to take the good with the bad. There will certainly be many, many cases that involve the flat rate billing fee of $2,015, for which the profit level of the qualified medical evaluator is small. But then every once in a while, a whale of a case with a huge volume of medical records will come in that will offset the minnows and would take the good with the bad. And I believe that over time, we're going to be doing just fine as qualified medical evaluators. So that was a whale of a case, and that represented a win for me. And the philosophy, the new philosophy that I want you to take to heart under the new medical legal fee schedule is that we have to be prepared to take some good with some bad. There are going to be cases that are whales, and there are going to be cases that are minnows. So let's now review a couple of different examples of actual cases under each of the medical legal billing codes and talk about the good and the bad. And remember that our overriding philosophy having to do with all of these medical legal billing codes, regardless of the page count of medical records that you get, even when you get 4,486 pages of medical records, time shall always be of the essence. So I want to talk to you now about a case that I recently had that involved a reevaluation of an injured worker, which under the new medical legal fee schedule, since it had been more than 18 months since the initial evaluation, this actually qualified as a new evaluation under the new medical legal fee schedule. So for the new evaluation, I was expecting to get the flat rate fee under the ML201 of $2,015. But unfortunately, as I suspected, the examinee was a no-show for the appointment. The examinee failed to attend the appointment, and for that, I was able to bill the ML200 missed appointment fee code for $503.75. Now, I was expecting $2,015 for a kept appointment, and so certainly $2,003 compared to $2,015 is a letdown, is a disappointment for the day, but at least there is some reimbursement under the new medical legal fee schedule, whereas the old medical legal fee schedule provided for $0 reimbursement for a missed appointment, which is simply crazy. But now we have a guaranteed reimbursement of $503.75. Now this examinee was notified of the appointment. I received a copy of their notification from the claims administrator, and at least from the claims administrator's perspective, this examinee was duly noticed on the appointment. In fact, it was my understanding that it was the examinee who had initiated the appointment, actually. And so it was a surprise that the examinee failed to show for the appointment. But she failed to show, and we were able to bill $503.75. Now, this code, the ML200 code, the missed appointment fee code, provides that in the case where the appointment has been canceled within 6 business days of the scheduled appointment date, if it's been canceled within 6 business days, you're allowed to bill the ML200 no-show fee. So on this particular examinee, when should we confirm the appointment? Should we call the examinee to confirm the appointment? We did. We called the examinee to confirm the appointment 5 days prior to the scheduled appointment date. We wouldn't call the examinee to confirm the appointment 8 days prior to the scheduled appointment date. What if the examinee cancels the appointment and we're calling and it's 8 days prior to the scheduled appointment date? Then we cannot bill for a missed appointment fee if she cancels and it's 8 days prior to the scheduled appointment date. So this tells us our incentive under this code is that we confirm the examinee from the 6-day viewer to the date of the scheduled appointment. So I called the examinee 5 days prior to the scheduled appointment date, and she told me that she had no knowledge of the appointment and that actually she was out of state and she would not be able to attend the appointment. I found this surprising, but that's what she told me. And at that point, I knew that the missed appointment fee was secured because it was less than 6 days from the scheduled appointment date. So I was able to know in advance that she wasn't coming. I knew this 5 days in advance, and I was able to fill that time with another appointment that I had scheduled after this particular appointment, move that appointment time into the earlier time slot, and it all worked out fine with the exception that I was unable to get the new appointment fee of $2,015, but $503.75 was better than a stick in the eye, and it worked out pretty good. I got $503 for no preparation at all. I had no preparation, no time involved, because I knew 5 days prior to the scheduled appointment date that she wasn't coming. So this represents a win, at least a small win, under the new medical legal fee schedule. So time is of the essence. The important principle for us under this code and for our new procedures in confirming examinees is that we confirm less than 6 days in advance of the appointment. Now, the burden of getting the injured worker to the appointment is up to the claims administrator. No longer does that burden fall on the shoulders of the qualified medical evaluator's office or staff, or even the evaluator, him or herself. It now falls on the claims administrator, because for a no-show, the claims administrator is on the hook for a substantial fee. But we need to know whether the examinee is coming or not, so we can still do our confirmation call, but we do that at a point less than 6 days prior to the scheduled appointment date. Well, what about a review of records? The ML200 code tells us that if the physician produces a record review report within 30 days of the date of the missed appointment, the physician can be reimbursed $3 a page. So when should you do your review of records? Let's say this case involved thousands of pages of medical records. You want to get paid for those, for that review of records. When should you do the review of records? When should you confirm the examinee? Well, the answer is the same. You start your review of records less than 6 days from the date of the scheduled appointment date. If you start your review of records at the 8th day and the examinee cancels, there's no reimbursement under this particular code. So this time frame of 6 days prior to the face-to-face prior to the scheduled appointment date is critical. You don't do any activities sooner than 6 days out from the scheduled appointment date, because greater than 6 days out provides for a $0 reimbursement rate. So that was a win. At least we were able to capture a missed appointment fee for what otherwise would have been lost time. But because I had 0 time involved in the evaluation, my effective hourly rate was infinity, really. $503 divided by 0 time is infinity dollars per hour. So that represents at least a partial win compared to an actual kept appointment. Now the next one I want to share with you, again remembering that time is of the essence, has to do with a reevaluation, which was a kept appointment. And this was actually the appointment that I was able to move into the earlier time slot. So as you know, the reevaluation is billed under the ML202, and this one involved a -93 modifier because an interpreter was required. So the value of this appointment was the flat rate fee of $1316.25 plus an additional 10% for the interpreter bump, for a total case evaluation of $1447.87. Now interestingly, this case came to me with 176 pages of medical records. Now this was a reevaluation. So some of these medical records I had already reviewed were duplicates of what I had already reviewed for the initial evaluation. And after I sorted through the entirety of these 176 pages of medical records, I found that only 40 pages of the medical records were new medical records. 136 pages of medical records were medical records that I had already reviewed. In any case, this is less than 200 pages of medical records. So I know that there's no additional reimbursement above and beyond that flat rate, which is allocated for the reevaluation itself. Unfortunately, it took me 2 hours, 2 full hours, 120 minutes to sort through the 176 pages of medical records and compare those medical records with dates of medical records I had already reviewed for the initial evaluation, and to then take the 40 pages of medical records and input those into my new review of records involved with the reevaluation took 120 minutes. Now this is where the claims administrator exercises her incentive by sending me the medical records and making me sort through the medical records myself and put the burden on me, on my dime and my time, to review those medical records. So this exhausted fully 2 hours, which is allocated towards approximately 4 hours devoted to a reevaluation appointment. So 2 hours are already gone. Then I spent 104 minutes face-to-face with the examinee. It took me 153 additional minutes to write the report, to print the report, to get the cover letters added to the report. In other words, to get this whole thing assembled and ready for billing. So my total time involved with the evaluation was 6.28 hours for an effective hourly rate of $230.55. So this is an example where I squandered too much time. I devoted too much time. My hourly rate dipped below what the Division of Workers' Compensation intends for us to be approximately $312.50 per hour. It dipped below even what is allocated for a reevaluation under the old medical legal fee schedule, which would be $250. If this was billed under the old medical legal fee schedule, my hourly rate would have been $250 per hour, correct? So due to poor use of time, my effective hourly rate dipped below even the former allocation under the old medical legal fee schedule. And now out of this hourly rate, and out of this absolute flat rate fee, I have to pay administrative costs. I have to pay staff costs for the administration of this appointment. This is simply the doctor time. 6.28 hours involved in doctor time, my time. In addition to that is the huge amounts of time, at least equal to that, if not greater, involved with the administration and the paperwork involved with this evaluation, involved with getting the appointment set up, sending out notifications, confirming the interpreter, making sure that we get cover letters, making sure that we got the medical records, confirming the examinee. I don't even know all the steps that go into the administration. I have that handled for me. And then the billing and the mailing of the report. And that's only on the first half of the administration. We still have yet to collect the payment on this evaluation. Typically, we initially get a $0 EOB, which requires follow-up, phone calling, resubmission of the report, reprinting the report, and the administration comes out of this hourly rate. So you can see that mismanagement of time, especially under the reevaluation code, quickly can erode any profit that was in the evaluation. So we have to take the good with the bad, and this might be an example of an evaluation that qualifies as the bad because the hourly rate involved with it is just not very compelling. Okay, so that was an example where the new medical legal fee schedule provides for a disappointing reimbursement rate, especially when you consider the costs of the administration of the evaluation. But as I said before, we have to take the good with the bad. Now, the last case I want to share with you has to deal with an initial comprehensive evaluation. Initial comprehensive evaluation under the ML201, as we know, bills for $2,015. And this particular case came with 80 excess pages of medical records, meaning we received 280 pages of medical records, so that's 80 excess pages. So that allows for additional billing under the MLPRR for $240. So the total value of this evaluation was $22.55. Well, in this particular evaluation, I spent 90 minutes face-to-face with the injured worker. I had some expenses involved with this evaluation. In other words, I had to pay rent at a satellite office location. I had to travel to and from approximately 100 miles each way to and from the satellite office location. I had some historian costs, and so there were some expenses of approximately $228 for this evaluation, which left a net of $2,026.90 left in the evaluation. Well, I had a total of 7.8 hours involved with the evaluation. That included face-to-face time, report preparation time, and drive time to and from the evaluation, which left an effective hourly rate of $259.85, slightly more than $250 time-based billing under the old medical legal fee schedule, but certainly much less than the intended $312.50 intended by the Division of Workers' Compensation, partially due to administrative costs and partially due to poor use of time. In other words, devotion of too much time in the total evaluation. The total evaluation projected to involve only 6 hours of total time. 6 hours of total time. 2015 divided by 6 is approximately $312 per hour. So the effective hourly rate on this evaluation was $259. Overhead was approximately 10%, which does not include the overhead involved with the administrative costs. So administrative costs, as I mentioned to you in our prior slide, also have to be subtracted from this. And so as you can see, as costs escalate, profits diminish, and the only variable over which we have much control is the time of the evaluation. And in this case, the 7.8 hours was simply too much time. So knowing what we know so far about the new medical legal fee schedule, to the extent that it can be known only 2 weeks into the effective implementation of it, I want to share with you what I consider to be some secrets of success. And the secrets of success is going to span the end of today's discussion, and I'll continue that on into next week's discussion as well. But before we get into the conclusion of today's discussion, I want to share with you a story that illustrates the principles that for us under the new medical legal fee schedule, time is of the essence. And I want to share with you a story to illustrate that principle. And it has to do with a story regarding a service call that I recently had at my house. In fact, I had a service call at my house yesterday. So at my house, I live in the El Dorado National Forest, and here at my house, we don't have city water, we have well water. So I have 3 wells, and the 3 wells all deposit water into a central holding tank, and the central holding tank provides water for all of our needs, our domestic needs, and also for landscaping needs. Well, over the weekend, the past weekend, I went to hook up a hose to a spigot out at one of the wells so that I could have a water supply for my burn pile. I wanted to burn some leaves and pine needles and down branches and stuff like that. And you're required to bring a water source to your burn pile, so I turned on the spigot, and for some reason there was no water coming out of the spigot. And this was a surprise because this has always been my water source for this particular burn pile at this edge of my property. So I don't know what's the cause of no water coming out of the spigot. So I called the service company at the well, down at the well company, and the technician came up to my house just yesterday. And the technician, with his infinite wisdom, took a look at turned on the spigot, saw no water, took a look at the dial, which registered 0 pounds of pressure, and he reached over and he removed a lid from several circuits and switches that were right there by the well. He was able to remove the lid with his fingers because the lid was not bolted down. It's not bolted down. It simply covers some circuits and switches. So he removed the lid, and sure enough, under the lid was a bunch of cobwebs and some dead spider carcasses, and apparently these cobwebs had interfered with the transmission of electricity through the circuits, and it shut off water to this particular circuit. So he leaned over and he went, he blew hard across the switches, and the machine came back on. It went click as he cleared the obstruction. In other words, he knew what to do. He knew what to do quickly to get it done. He blew some of those cobwebs off, and instantly the circuit was restored. And we as qualified medical evaluators, we need to know what it is we need to do when we go into these evaluations. Otherwise, we're spending unnecessary time and eroding profits. So then the technician said something interesting. He said, looking at this circuit, I would just replace the whole circuit. And I thought to myself, well, I wonder what the cost of the whole circuit is. I know I'm already into this service call with him blowing on the circuit. I'm into this service call for a minimum 1-hour service call. So can this circuit be removed within the same hour? And what's the cost of the circuit? So I said, what's the cost of the circuit? And he said $35. Now, for blowing on the circuits, he gets his 1-hour service fee of $150. Guaranteed. It's a 1-hour minimum. He cleared the circuit. I now have water. If he wanted to lean over there with a toothbrush and do a minute or two to clear off the cobwebs, that would have been additional service, right? Which would start to cost him more time. But he chose to replace the existing circuit board, much as like we get additional income from the review of records. But replacing the existing circuit is going to cost him some time, for which he's already receiving his hour minimum. So to replace the circuit is going to cost him time. But for me, if the circuit's low cost, would be a valuable use of his time, because I'm already paying for 1 hour of his time. So I asked him, how much is the circuit? And he said, well, it's $35 plus 7.25% tax, comes to $37.50. So for $37.50 for what I'm already paying for a 1 hour service call, my incentive is maximized, because I get a new circuit, I get some use out of his time while he's already there. For him, it might have been considered a bad decision to suggest the replacement of the circuit for only a $35 additional profit, much as for us, an additional 50 pages of medical records is only an additional $150. Is it actually worth the time to review those additional 50 pages of medical records? That's for each of us to decide, but again, time is of the essence. Just as it was for the service technician who came, and after I paid him, I said, let me pay you now. That way I can go about my business, you can go about your business. After he wrote up my invoice for $187.50, $150 per hour service plus the part, he said to me, I'll be gone in about 10 minutes. So he was able to capture a 1 hour service call for 10 minutes of labor processing this new circuit board, because, key principle, because he knew what to do. He knew what to do. And we as qualified medical evaluators, we need to know what we're doing when we get to the face-to-face evaluation, so that we can resolve the issue quickly, just as he did, get out of there profitably. So again, time is of the essence, and I want to just reiterate something that we talked about last time. And I'm going to give you a new suggestion as to something we've just learned in the last few days. And that the labor code that's driving the need for the evaluation is critical. If you can understand which labor code it is that has been instrumental in ordering your QME panel, then you'll know exactly what to do. Just like the well technician, he knew what to do. He arrived knowing the fix, the time-effective fix of the problem. So, as a practical application of this idea, so that you can know better what it is that you're getting into right from the very inception, I want to suggest to you that you make some changes on your intake document when your initial phone call comes in for the QME appointment. When your initial phone call comes in, it's critical to reduce your administrative costs, so that there's some profit left in the evaluation. It's critical that you reduce administrative costs. Administrative time and administrative costs is one of the variables you can tinker with in maximizing your profit under the new medical legal fee schedule. So you do that by getting all the information that is required for the evaluation up front. Up front. Did I say up front? I mean up front, one time in one fell swoop. If you fail to get complete information up front, you simply have to spend more administrative time requesting the required information. So required information when you get a call for a QME appointment is at least the information that is required to fill out the appointment notification form. You need to have complete information to fill out the appointment notification form. So tell the parties the information that you need to have them send to you. Make sure that you ask the requesting party what labor code, under what labor code is this evaluation being ordered. They're going to say, what? Well, ask them, is this being ordered under 4060, 4061, or 4062? And get their answer, because their answer tells you right away the direction that this evaluation is going. Ask the parties to provide you with the strike letters that leave you as the last man standing on the panel. This is critical. When you get a call for a QME appointment, that call is nothing more at that point in time. It's nothing more than a request for an appointment. And a request for an appointment is not the same as a bona fide, verified, compensable appointment. Many times qualified medical evaluators take in these appointments where later on one or more of the parties objects to the appointment. Meanwhile, you've spent all this administrative time setting up the appointment, sending out notices, and wasting all this time when at the beginning it wasn't actually a bona fide, verified, non-objectable appointment to begin with. So strike letters are critical. You don't want to go through the administrative costs of setting up an appointment only to have one of the other parties come back and say, we never had an opportunity to strike, or we never received the panel, or we're objecting to the specialty of the panel, or for whatever reason, after which you've already spun your wheels and lost administrative time. Time is of the essence, and admin time is one area where you can maximize your profits. Finally, get the email addresses of all parties, including the claims administrator, the legal secretary at the applicant attorney's office, the defense attorney's legal secretary. Email communications facilitate the exchange of information in a time-effective manner that will help you reduce the total time involved with the evaluation. So these are some practical suggestions, and you might even tinker with your own intake document that you request the parties to fill out when they select your doctor or you as the last man standing on the QME panel. You might provide a document to the parties to have them fill out, for which they expend their administrative time filling out the document, providing you with all the information that you need on their dime and on their time, versus the other way around. Now, you're going to get some resistance to this because the other parties have the same incentive as you do, but it's only fair that you demand complete and accurate information up front, the necessary information that you need to move forward with what becomes a confirmed, bona fide, and verified appointment. So doctors, I hope these ideas help you. These cases that I shared with you today show you actual use of the medical legal billing codes and how the numbers and how time factors in to the evaluation process. So again, the operative principle is that time is of the essence, and in these evaluations we're going to have to accept some good cases, some whales, some home run cases, and we're going to have to accept some cases where the profit margins are a little bit underwhelming. And over time, I believe that the new medical legal fee schedule will show itself to be an actual pay raise for us compared to the old medical legal fee schedule if, and this is a big if we can be like the well technician who comes to the job knowing in advance what's necessary, knowing in advance what's not necessary, getting to the issue and resolving the issue in a timely fashion. And if we can do that, we can be profitable under the new medical legal fee schedule. And in our next session, I'm going to share with you more examples as to how to do exactly that. So I want to thank you today for taking the time to join me on this discussion. I look forward to being with you on our next discussion, as well as we conclude our ongoing series regarding the new medical legal fee schedule. For now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.